As Susan said, I'm the brand new director of the brand new Global Women's Institute, founded exactly 2 months ago. We're so happy to be hosting, together with the College of Professional Studies and the Law School, our very first public event. The Global Women's Institute was created to strengthen GW's response and support for improving the lives of women and girls throughout the world through research and education and through civic engagement, which is, you know, kind of not too modest a goal, really. So one of the ways that we're going to do this is really by supporting and strengthening and showcasing the work that's already ongoing on campus through all of our schools. And I was very lucky to meet Toni early on, and she told me about the work of Naemy and the work that she'd been doing in Tanzania. And we heard that Naemy was coming to Savannah, Georgia, which is practically next door. And so we said, you know, well, we want her in Washington. We want to hear more about this program. And so we're really excited and grateful that Naemy made the extra step to come to Washington. And then, of course, another part of our goal and our strategy is to partner with local and international groups that are doing similar work. And that's why we're so happy to start our series off with Stella Mukasa, who's the Director of Gender Violence and Rights at ICRW, the International Center for Research on Women, which I think of as my alma mater, but it's not exactly. That's where I was working before I came here. There must be a word for your source. So, as I said, this is our first public event, but you will be hearing a lot more from us in the future. Already we're gearing up for a very exciting program in November and December around the 16 Days of Activism Against Violence Against Women, which is a yearly campaign that's held throughout the world. And we're going to be honoring here at GW, together with a lot of different schools, the Public Health School, Media and Communications, Professional Studies, the Law School, and the Columbian College with the Women's Studies program. We'll also be working with the Interagency Gender Working Group, ICRW, and the Pan American Health Organization to have a whole set of activities between November 25th and December 10th. So you keep that in mind already. December 27th is going to be the launch of the Institute, and President Knapp will be joining us for that. So please sign up before you leave, and we will be keeping you updated with all of our future activities. So we have 3 expert speakers today, and I'm going to say a little bit about each of them and then let them take over. Our first speaker, Stella Mukasa, is the Director of Gender Violence and Rights at the International Center for Research on Women. Stella is a lawyer with 20 years of experience in gender and human rights, spanning government, international development, and academia in Uganda and throughout East Africa. She began her career in 1993 at the Ministry of Gender and Community Development in Uganda, where she participated in developing the 1995 Constitution of Uganda, which established some of the most progressive reforms for women in the region. Since then, Stella's been an advisor to governments, national and international organizations on gender-responsive policy development, and 2 of the areas most recently that she's contributed to have been the Constitution of Rwanda and Uganda's Domestic Violence Act, which was passed a little over a year ago. She's also a part-time lecturer on gender law and human rights at Makerere University in Kampala, Uganda. Naemy Sillayo is the newly appointed coordinator of the Paralegal program at the University of Bagamoyo. She was selected from a group of young professionals who comprised the inaugural paralegal training course at the university after completing the program at the highest level and being chosen by her colleagues to speak at the class graduation. As the University of Bagamoyo now hosts the first and only formal paralegal education program in the nation of Tanzania, Naemy has piloted a project to educate rural Tanzanians about the upcoming redrafting of the Constitution. She's traveled to villages throughout the Serengeti region to develop an education program and to train regional paralegals to disseminate the program. And finally, we have Toni Marsh, who is the founding director of the award-winning GW Paralegal Studies program and an associate professor of paralegal studies. Together with the Legal and Human Rights Center in Dar es Salaam, Tanzania, Professor Marsh Marsh designed the International Rule of Law Paralegal Clinic in Tanzania, in which GW Masters candidates work alongside Tanzanian paralegals to provide paralegal services to rural villagers. In partnership with the University of Bagamoyo, Professor Marsh has just designed and launched the first ever formal paralegal education program in Tanzania. She's the author of Juvenile Law, several articles in professional and educational publications, a frequent presenter at national legal conferences, and the creator of Corporate PEP, a paralegal education program for corporate paralegals that runs every May in Washington, D.C. So the way we're going to do this is we're going to ask Stella to give a bit of an overview of what are the kinds of barriers that women face in terms of access to justice throughout the East African region, and what are some of the strategies overall that women's organizations and lawyers together have been developing to overcome these barriers. Then we're going to go into a specific case, which is Tanzania and the work of Naemy, and she's going to tell us about the work they've been doing with paralegals for the last few years. And then Professor Marsh will be ending the panel by talking a little bit about GW's program and how we've been engaged in this, and what our future plans for engagement will be. So that will be about a half an hour, and then we're going to have some time for questions and answers and discussion. So we won't have any questions after the first presentations. We'll save that for the end. So thank you again, and I will now hand over to Stella.
Thank you, Mary. A good afternoon to you all. And I would like to first of all thank the George Washington University and the institutions that have been involved in putting this together. I come from a country, Uganda, where in many instances, whether it's the relationship between state and citizens or citizen to citizen, you talk a lot about doing things together or doing certain things and never somehow getting there. So I would like to thank you, Mary, for activating this partnership and making sure that we get to do this today. It's my pleasure to be here to share my experiences of work on women's rights in East Africa, and to have a discussion about the same. I'll be speaking on the title, Gender and Access to Justice in East Africa, some challenges, strategies, and outcomes. And in summary, my presentation will be done this way. I'll give a brief overview on key concepts, and then I'll speak to what the gender-related barriers are in accessing justice and where they're located. Then I'll speak about strategies that we've employed to date to address the barriers. And in there, I hope to highlight the contribution that ICRW is making in the East African region, and then end with the conclusion. By way of key concepts, these are the two main ones that I'll be dealing with. Gender as a social construction of roles and responsibilities. We recognize that it confers power, status, opportunities, and privileges differently to men and women, and all these are done through a socialization process. And the lessons we pick from this socialization process stay with us really long and are difficult to unlearn, that you find they influence many times how we go about our professions rather than vice versa. And this is what I want to emphasize in speaking to some of the gender-related barriers in accessing justice. And then speaking to justice, it's just one of the various attributes of law that creates standards of rights defined and enforced by specific institutions, and the state bears primary responsibility. But we also know that law has other attributes, such as experiencing it as a power relation. You can also, speak to law as a social process that evolves and is recognized as customary law. Now, coming to the gender-related barriers in accessing justice, I speak to them from three spheres, as in terms of where we they're located, and that is the substantive laws, the administration and enforcement of law, and the community in which conflicts or disputes occur. And I will highlight the issues briefly on each of those. In the area of substantive laws, 3 key issues emerge. We have gender-biased laws, laws that are overtly discriminatory and provide differently for different genders. I would give an example. Until women's rights organizations challenged this provision in courts of law successfully in a constitutional court, we used to have a different definition of adultery in Uganda for women and men, such that for men, adultery is about a married man having a relationship or sexual intercourse with another married woman. But for women, it was a woman who's married having a relationship and sexual intercourse with any man. And that was the standard that clearly was informed by interests and standpoints that, imply that men can have sexual intercourse with any woman as long as they don't interfere with the relationship of, the married relationship of another man. And those are some of the issues that we've been contending with, issues around burden of proof and other laws. Then you have the gender-neutral laws that are not overtly discriminatory, but they don't, they do not provide a clear position that recognizes that these different genders come from different standpoints to experience the law. And then you find that in the process of experiencing that piece of legislation, women are disadvantaged simply because of where they come from. So for example, if you say that the law is that all people will register for elections at 10 a.m. and this is the time that women are involved in doing their household chores, their domestic chores, it's not saying do not come to register, but they will simply not turn up. And these are some of the issues that we've been trying to unpack in terms of what legislation there is to ensure that it is gender responsive. And then we have cases where we have legislative vacuums, whereby there's just no protective legislation. And a case a classical case is the question of domestic violence, where we've just simply not had legislation. There are areas such as the question of marital rape, which has also, been and continues to be an issue in different areas of the law. Then in the area of the administration of the law, some of the gender-related barriers include the issue of physical proximity to justice delivery agencies. You find that there are vast distances between, where women experience these challenges and violations and places where they can go to seek help. And I say this, I speak to women, men are there, but they have their social networks. They are not confined to the domestic sphere. They are moving around, they are working, they're socializing, they're going to the trading centers. So they have easier access to these points of justice delivery more than the women. The other issue relates to the attitudes of personnel in the enforcement and administration of the law. And this is experienced by a number of women from a day-to-day basis, in the sense that, when she finally, after all the hurdles, makes it to a justice delivery point, such as a police station, to report a violation, for example, domestic violence in the domestic sphere, she will be told by the police officer, that's a domestic matter. You need to go and sort it out at home, and therefore, finding herself at a loss. And then you find that these, again, like I said, we learn these in the socialization process, and they're difficult to unlearn We have heard about cases of judges who, have said recently there was a case in a state in India, a judge who was admonishing a woman to take heart over the domestic violence that she was encountering, because that is supposed to be the normal part of the normal wear and tear of a marriage relationship. We have another classic case that we normally quote in regard to this example of a judge who, in the course of hearing a case of rape, the lady who had been violated, an elderly woman, stood before the court, and because she could not culturally bring herself to say the word sexual intercourse, she said to the court, "It was raining. I was standing by his door to take shelter from the rain, and in the rain, this man dragged me into his house and made me his wife." And the judge said she hadn't adduced evidence to the effect that this man had actually raped her, and admonished her for, saying younger children are able to talk and say exactly what happened, and she lost the case. So these kinds of attitudes, even with a person who has gone through the level of judicial training to sit before and arbitrate a case like that, then you find that there are issues of technicalities in the legal process, and these relate very much to, again, the gender issue of the fact that women are more illiterate because they have less opportunities to attend school and education, and they're very much confined to a domestic setting, so they lack the social networks where they can pick up this kind of knowledge and information. They are intimidated, and they find this whole system and process completely alienating. We, in the context where we're operating, there's the whole question of ineffective and inefficient operations, where you find that the way justice is administered is totally inefficient. A day will come where they will bring in persons that will be, the prisons will bring in the people who are supposed to appear before a court, and all the people who are supposed to adduce the evidence as witnesses will turn up, and that's the day the magistrate will call in sick without, will simply not turn up because they had other business to do. And, cases continue being adjourned and pushed ahead and postponed. And this delayed delivery of justice has direct implications for the cost that, one incurs in terms of traveling and coming, the opportunity cost between staying home and minding and handling the domestic responsibilities and coming to court. All these issues increase the cost, especially for women who, remember, do not also have the decision-making power on the resources in the household in terms of, whether or not she should go to pursue a case like that. Then there's the question of corruption, which automatically increases cost, and in many instances women are manipulated, many times it's clerks or other support officers who work in these agencies that are telling them, if you're going to be able to get bail, you need to pay, and you pay to me, and out of ignorance, they continue to incur these costs and ultimately a higher cost of justice for them. In terms of the community where these disputes or conflicts occur, is, the headline issue is the patriarchal value system, which informs very much decisions on whether or not somebody will step out of their confines or their context to go and seek justice. It privileges the male, and many times for women, there's that shadow hanging over her, taking a matter out of a domestic setting. And again, I'm giving an example of violence in the home, or it could even be incest, it could be physical violence. taking a matter such as that to a third party for arbitration can have very grave consequences for her in terms of her family. The extended family should be ostracized for taking what they call private matters to a public sphere. So in many instances, we find that women hold back. Then you have the gender power relations within the household, the decision-making power on resources and how resources are spent, and who does what, who goes out, who does the reporting, and what kinds of issues you should seek justice about. She needs many times to ask for permission to even get out and go out of the house. She has to explain all her movements. And many times, for lack of, a convincing explanation, you find that they will hold back. Then you find that we have plural community-based dispute resolution fora. These include, you have local courts, you have the traditional setting, and you have sometimes religious platforms to which people can go. And many of these, especially the religious and the traditional, are not favorable to women because they tend to reinforce the kinds of issues that the patriarchal value system upholds. For some of the religious settings, she may be able to get a good judgment, but she will still not be able to enforce it and cannot have an opportunity to get back. I hinted onto the issue of illiteracy and ignorance of rights, ignorance of which laws are there, which procedures, who to go to, where to go. All these are issues that impinge on justice-seeking behavior. And finally, I will hint, it goes without mention that people in situations of conflict, transition, and post-conflict, it's a whole vulnerable and volatile situation. Law and order breaks down, and the situation is in free fall, and in many instances, a lot of investment has had to be done to ensure that, culpability is established and perpetrators are brought to justice. So developments such as the International Criminal Court are, very welcome developments for women's rights in these contexts. That in a nutshell speaks to the barriers and the various spheres where they're located. And in terms of strategies and outcomes, again, these have also matched the barriers and challenges. Now, in terms of the substantive laws, strategies have essentially targeted the lawmaking and law reform processes. They've targeted the parliaments or legislature, with gender sensitization or gender analysis of existing legislation and advocacy to ensure that there's more responsive legislation. Women caucuses in parliament, these are groups, that are set up by the now ever-growing development of women in political participation. So women in parliament have really made a difference to the statute books. There's a very distinct difference between the kinds of laws that were passed prior to an increased participation of women in parliament and in lawmaking. They're really making their voices heard, and that's a cause for celebration. Some interventions have targeted the offices or units that handle legislative drafting, talking to the very people that actually sit down and draft this legislation. And on this, we speak from experience, for example, in Uganda, where there was a clause around protecting women's land and property rights in marriage that was fully discussed and debated in parliament and actually, passed. But the people capturing the Hansards, the parliamentary recording, skipped, for some reason, did not capture the adoption of this debate. And by the time it got to the drafting section, we were talking about a lost clause. And you will probably hear, if you speak to activists from Uganda around the lost clause on women's land and property rights. So these are important offices to target, to weighs their consciousness on making sure that they're drafting legislation that is gender responsive. There's been a lot of advocacy by the women's rights organizations in Uganda on law reform, and Kenya actually. Tanzania is right now going through a constitutional review process, so there is a great opportunity there. But the constitution making process in Uganda, in Kenya, and Rwanda has generated very, gender responsive constitution documents. Marriage and divorce is another area where women have had to do a lot of work. In Uganda, it's been more than 40 years that we have been advocating for a fairer marriage and divorce law, and we still haven't got it, but we're not giving up. Successfully, there's been good advocacy, strong advocacy that has generated a legislation on domestic violence, which should have actually been captured under the marriage and divorce, but because this was taking a long time, the strategy was to say, let's continue, let's start to piece it, get it in a piecemeal process. So we have domestic violence legislation, so does Kenya, and I believe Tanzania. A lot of success has been registered in inheritance and succession and land and property rights. These are areas where the International Center for Research on Women is doing commendable work in terms of strengthening the capacity of women's rights organizations in Uganda and right now in Tanzania, strengthening their capacity to undertake advocacy and strengthening capacity of people who are doing paralegal services to do their work better and to monitor and demonstrate results, generate the evidence that will be informing policy options. Strategies in the area of administration and enforcement of law, have essentially centered on justice sector reforms, which are very much supported by bilateral donors, the U.S. government inclusive, which seek to increase proximity so that, to justice delivery agencies, and interventions that seek to enhance the efficiency and effectiveness of justice delivery agencies. So you find programs targeting the police, the judiciary, the Ministry of Justice. All of these, though they may appear gender neutral, for women's rights work, it means a lot to bring a court or a symbol of justice delivery closer to where they are, and therefore easier for them to access. Going along with that has been gender sensitization of these officers. Many women's rights organizations are doing great work in strengthening the gender analytical skills and sensitivity of these officials, helping them to unlearn the lessons they picked up through socialization, and also mainstreaming gender into the orientation and training of these officers. Legal aid services are very great intervention that have improved access to justice for women. Primary and secondary education, legal aid services. In terms of the secondary, I would like to speak directly to the issue of paralegal services, which Naemy will elaborate on very shortly. They've also invested in self-representation of women, empowering them to go before court and represent themselves with the support and cheer of other women. There's also been strong advocacy for implementation of protective legislation, and in all these cases, ICRW is working along with partner organizations in the region to enhance performance and programming. The other issues are indicated there on the slide, but I would like to make specific mention on the question of strategic litigation. This is one of I think it's one of those very promising and successful strategies that have been employed. For example, the adultery definition I spoke to earlier was thrown out of the statute books through strategic litigation, and there have been many others around succession and inheritance, where women have taken cases to the Constitutional Court, petitioning to say this is unconstitutional, it's against standards of human rights and justice, and we can see that the courts are beginning to yield. The community, this is the work that a lot of people are doing. It's not essentially legal work, apart from the sensitization, legal education and awareness, and the work that seeks to target a shift in social norms. A lot of the work that seeks to address the gender inequality will directly bear fruit in terms of how women and men step out of their context to go out and seek justice. So a lot of research and evidence that seeks to inform policy options is being done, again, by the International Center of Research on Women, to support these processes. I wouldn't like to leave this slide before talking about the challenge to customary law that some of our partners have done. A group called Mifumi have actually challenged the practice of bride price, and they have had a community pass a bylaw that outlaws bride price successfully with the support. I mean, it was a lot of community organizing, but it just shows that if you make the investment, it will bear fruit. In conclusion, I think I would simply say that the interface between gender and access to justice clearly speaks to the attribute of law as a power relation, and that is manifested in how laws are drafted or made, how they're enforced and administered, as well as in the factors that impinge on justice-seeking behavior by men and women. There have been a lot of advances in inequality before the law, in terms of legislation. However, challenges still persist in the administration and enforcement of law, as well as the challenges we've spoken to at community level, and the story and the efforts must continue. I thank you.
Honorable invited guests, ladies and gentlemen, good afternoon. It's such a great honor for me to stand before you here today to extend my hearty thanks for this phenomenal opportunity granted to me. Being the coordinator of the paralegal training programs from the University of Bagamoyo in Tanzania, and being so junior in the field, I believe the knowledge and skills that I've acquired during the AFP program that I attended in Savannah, and the experience that we're sharing here today, will be a very useful tool in the institutionalization of paralegal courses in my country, Tanzania. Lack of adequate legal framework to address legal issues in the country has led to increasing number of violations of human rights and delay in delivery of justice. For this reason, therefore, the role of paralegals is of paramount importance in the promotion and protection of human rights, as well as enhancement of social justice in my country. The paralegal context is slightly different from the paralegal context in America. Paralegals back home are people trained from grassroots levels, and the service that they render are usually more accessible to the poor and the vulnerable in the rural areas. Their duties, among others, are to help their respective communities by providing legal assistance, legal awareness, and legal training and advocacy. Therefore, on behalf of the University of Bagamoyo, I must mention our deep appreciation to George Washington University for their willingness to work with us and help us in, starting this inter-university intervention to establish the paralegal courses there. The University of Bagamoyo will be the very first university in Tanzania to have formal paralegal education, and we're therefore looking forward to have an outstanding curriculum that will ensure paralegal works are recognized both by the government and by other citizens. And the main purpose is to increase the efficiency and quality of services that our students will provide after completion of the courses. I cannot thank everyone enough, but allow me to thank Professor Toni Marsh for her full-time support and personal involvement to ensure that I'm here today with you. Through her also, may I thank the George Washington University for their support and collaboration with my university, and to all individuals that made contributions to bring me here to the great country of America. From the very bottom of my heart, I'm very grateful to you, and may God bless you. So let me tell a little bit about Tanzania for those who don't know. Tanzania is situated in the eastern part of Africa, and it has a population of almost 40 million people. We are following a common law system, and because we are a former British colony. And other sources of law includes customary laws and Islamic laws. There are a number of problems facing the legal sector in my country, and one among others is insufficient number of lawyers. One of the Tanganyika Law Society reports indicated that there are almost 2,600 registered lawyers throughout the country. So you can imagine 2,600 serving a population of 40 million people. It's not possible. And most of these lawyers are concentrated in urban areas, so their costs are very high and they're very unaffordable to the vast majority. Also, there's lack of adequate legal framework, like there is no any legal aid law that will address legal issues, and this has led to an increased number in reported cases in violation of human rights. Most of the Tanzanians have no legal knowledge because they have no access to it, and there's also the issue of lack of independence of the judiciary. The judiciary has largely been politicized, thus the rule of law is not realized. So the paralegal works in Tanzania started in the early 1990s, and it was initiated from non-governmental institutions. And paralegals, as I've mentioned before, they're people who are not educated, they just come from the local communities, and most of them, they would volunteer because some of them are victims of, different cases. The importance of paralegals in Tanzania is so immense. Like what they do, through the work of paralegals, the importance of paralegal works in Tanzania, first is expansion of legal aid services and education, especially to the vulnerable people in the rural areas, and then promotion and protection of social justice. This can also be realized through the work of paralegals, and also paralegals act as human rights watchdogs. And through the work of paralegals, there have also been a reduced number in cases that have been taken to courts, because most of the time there are some cases which will not really need to go to court, but through the work of paralegals, they'll just solve them amicably. So the University of Bagamoyo, we did a TOT program, which Professor Toni Marsh conducted it in March this year. And we were a class of 40 lawyers. After we finished the course, most of the participants of the program, they went back to their communities, and they're working with different organizations, and the university has access to them whenever we have any program that we would like to run. And this last August, we had a pilot training with Toni again. She came to Tanzania, where we were working on the constitutional reform process, where we were doing some public hearing, where we would, provide like civic education to the community, tell them what's the constitution, why should they participate on this whole process, and why is the process important to them and the welfare of the country. Therefore, the presence and roles of paralegals is of very paramount importance in my country, because it will help in addressing gender inequalities through the gains made by women's rights movements, and exploring how women's rights play a part in issues of poverty, HIV/AIDS, gender violence, and reproductive health rights. It will also help in strengthening democracy through civic education movements and mobilization of civil society organizations, and also having capacity building programs that will empower paralegals to understand women's rights and how these rights can be promoted. Thank you.
Well, thank you, Naemy and Stella and Mary, and thank you all so much for coming here today. This is it's a historic event. It's our first event with the Global Women's Institute, who we are so delighted to welcome to George Washington University. And I appreciate you're all coming out here and supporting not only the GWI and the law school and the College of Professional Studies, but also this very important issue of women's rights in East Africa. So let's see if I can figure out how to do this. And there we go. Okay, so what I'm going to talk to you about today is just how GW came to be involved with the University of Bagamoyo and with paralegal education in Tanzania. So I'll keep it very quick. It all started about 5 years ago when a woman named Helen Kijo Basimba was here in Washington, D.C. as a guest of Condoleezza Rice. She was here as part of Condoleezza Rice's International Women of Courage annual ceremony. She was being honored as an International Woman of Courage. Helen is the executive director of the Legal and Human Rights Center in Dar es Salaam. And so she knew that in a country of 40 million people, about 2,000, 2,500 lawyers to serve all of those people, and most of those lawyers concentrated in the big cities, there was a real problem of access to justice. And as both of these distinguished speakers have mentioned, when you're talking about access to justice, what you're really talking about is women's access to justice. There are 3 parallel legal systems running in Tanzania at the same time. There's the formal common law system, there's the tribal customary system, and then there's the religious Sharia system. Men have the tremendous advantage in the customary systems and in the religious system. So women are the ones that really need to take advantage of the formal legal system, because the formal system, with its rules and its level playing field, give women that advantage that they lack in the other systems. So when you're talking about access to justice, you're really talking about women. So we knew she knew that her country had a problem that she needed to solve, and the way that she knew that she needed to solve it was through the use of paralegals. She knew that Tanzania needs more paralegals. And so it was my great good luck that she came to Washington, D.C., and she asked at the State Department, are there any paralegal programs in Washington, D.C.? And they said, yes, George Washington University has got a program. So she called me, she came to visit, we talked about the problem, we kicked around some ideas. It took us a while to really come up with a good model. We developed a paralegal clinic where I brought my American, GW student master's candidates to Tanzania to work in the legal clinics, and one of my students, Jamila, was one of those students who went over to Tanzania, and we just had an absolutely wonderful experience there. And it was a good model, but it wasn't big enough. It wasn't sustainable enough. It was, my students were going over and they were able to help a few people, but what we wanted was something that would branch out and grow throughout the nation. It was also our good luck that right at that time, the Legal and Human Rights Center began to become involved with the University of Bagamoyo. They acquired some land in Bagamoyo, and I just have to tell you very quickly, I don't have a picture of it, but the very location of the university is meaningful and quite poignant. The city of Bagamoyo is on the east coast of Tanzania. It's on the Indian Ocean, and it was a slave trading port. And if you go to this very, very beautiful, beautiful city with sugar white sand and beautiful turquoise waters, there on the sand are these big stone pillars with iron bars coming up, and that was where the slaves would be shackled as they were waiting to be taken off on the ships, which were waiting in the Indian Ocean to take them off to a life of slavery in the Middle East. And all hope was gone. And they would, the word Bagamoyo means lay down your heart. They would take their hope and they would lay it down on the sand. And the University of Bagamoyo came in and said, we are going to pick up that hope and build a university from it. And the university is dedicated to human rights. And the motto or the tagline of the university is, in Bagamoyo we were enslaved, and in Bagamoyo we will be set free. So they started the University of Bagamoyo, and it was a university dedicated to human rights. It's just opened up, and of course, the very first program that they wanted to have was a paralegal education program, knowing that this would be the road to human rights. So I went over there in March, and I designed a program. There's my class. And I brought over a suitcase full of George Washington University t-shirts, and that's what they're all very proudly wearing in front of the beautiful university. And let's see, that's the entrance to the University of Bagamoyo. It's in just a lovely, lovely building right on the ocean. But as we've said a few times already, it's the first formal paralegal education program in the nation of Tanzania. There are many, many, many paralegals in Tanzania. They live in the communities. They come up from the communities. They're people who are citizens of the residents of these communities. They're wise, they're respected, they're admired, they're smart, they're usually literate. And so they rise to become paralegals, which is a very prestigious role to occupy in the nation, in these villages in Tanzania. But there's never been a formal training program, so that's what this was meant to be. And this was a program that was meant to train trainers, so that these people, those 40 students that you saw, would then, as Naemy said, go back out to their communities and teach others. So this is highly sustainable, and it will grow. And it was just, we finally came up with the right model. The really fun thing about it was I went out there and I had 40 brilliant, energetic, smart, charming young people who were so eager to learn. And so we just, we dug in, we rolled up our sleeves, and we as a group designed the program together. So I didn't walk in and say, okay, here's your program, here's how you guys are going to do it. Because they needed to learn. I was going to leave and they had to know how to do it themselves. So I went in and we worked as a group to design this program. And so as we were designing it, they were learning to design a program. The other thing is, as I was teaching them, I would stop and tell them what I was doing. And we would talk about the teaching techniques that I was doing to them and teaching them how to do it. And it was great fun. For me anyway. I hope it was fun for them. They didn't kick me out or ride me out on a rail, so I guess it was okay. So really quickly, what we did the very first day that we worked, we brought in working paralegals from the field, people from the villages. We brought them in, and we had them lay out, list what they do. What do you do in a day? Tell me what your day consists of. What do you do in a week? So we had them go through their day and their week. And I have to just take a step back and say that Jack Prosco, my colleague and fellow associate dean, helped me to devise this lesson plan. I'd love to take full credit for it, but Jack had a very, very big hand in designing this plan. So we had them come in and list what they do all day, all week, and then what they do in a certain task. So take me from this client walks into your office or this woman walks into your office all the way through you've solved her problem and sent her on her way. So we came at it from two angles and came up with just this random list. We were writing it on the board. We had no PowerPoint. We had no laptops. We had no smart boards. It was just a whiteboard and a magic marker. I had a magic marker. Thank God it didn't run out of ink, because I don't know what we would have done. And each student had a steno pad and a pen. And that was it. And that's how we did our work. And I just have to say, it was fabulous. We got so much done. Absolutely no distractions. But anyway, so we listed it. We just wrote it all on the board, all randomly, as people thought of things. And then that took us a whole day. The next day we came in and we started taking those tasks and we started grouping them. We started putting them into groups. We divided some tasks, we combined some things, we put them into some sort of an order. Those tasks then became, those groups of tasks became courses. So we came up with courses, and the tasks that were within those courses then informed what would be the learning objectives for those courses, which then became the syllabi, and the course design, the outline of those courses, and then we even designed the pedagogy that would allow us to achieve those learning objectives, and even devised the rubrics for those assignments and the syllabi for those courses. So that was how we came up with that. And these are, I just have to say, so here are my students hard at work. You can see them conferring together and working together. By the way, the woman in the green shirt works at the Legal and Human Rights Center and is a paralegal. So she was one of the people that helped us to come up with a list of tests, but she also participated in the program. You see them there working in a group. At the end of the course, they said they loved what they did. They enjoyed it so much they had never worked that way before. They had never worked collaboratively. They had never engaged in that kind of active learning. They were used to sitting in rows and having a professor lecture to them. So they really enjoyed it, and they took to it like that. I mean, by the second day, they were just time to get in our groups, and just really enjoyed the collaboration. 40 students, you've already heard that. Now working throughout Tanzania. Naemy Sillayo, who was in the class, was selected by her colleagues, as you've heard, to be the commencement speaker. And to my great delight, I was up on the dais with the Archbishop of Dar es Salaam, the Chancellor of the University, the Chief Justice of the Supreme Court, many members of the Board of Trustees of the University. We were all up there, the Director of the Legal and Human Rights Center. And as Naemy were speaking, they were all looking at me saying, wow, she did a fabulous job. They were so impressed. And after it was over, she said, earlier in the course, I had the students do oral presentations, and I had a rubric, and we used the rubric to assess their oral presentations, and then I showed them the rubric and what they were being assessed on. And after it was over, she said, Professor Marsh, I remembered that rubric, and I made eye contact, and I thought about my message, and so it was really nice to know that, I see your work in action. And then she ended up being selected as the Paralegal Studies Program Director. So realizing that she was the only Paralegal Studies Program Director in the entire nation of Tanzania, I knew she had no colleagues, no peers. So when I made plans to attend the national conference for the American Association for Paralegal Educators in Savannah, I thought it would be a great idea for Naemy to come. So I sent out a notice, we raised the money. The GWI generously added to that to bring Naemy here to Washington, D.C. GW kicked in some money, we brought her, and we just had a fabulous, fabulous week in Savannah. Naemy collected a lot of business cards, and we were just the stars of that conference, weren't we? We were just the superstars. So that was how Naemy came up into that position. And then I went back in August thinking I was just going to go back and assess the program and see how the program went. But as it happened, there was this constitutional review going on in Tanzania, and Naemy and her colleagues, Naemy came up with this project to go out to the villages to educate people about the upcoming constitutional review. And they were going to conduct a pilot of this project and go out to 2 villages in the Serengeti region. And so I got to go with them, and darn it, we had to drive right through the Serengeti National Park to get to this village. So it was a long drive, but we did get to see lots and lots of, it was a safari. I mean, going out, we got to see lots of it. It was an absolutely gorgeous country. If any of you ever get the opportunity to go to Tanzania, go. Absolutely go. And go in August, because that's the most beautiful time of year. But these are some of the villages. So we went to 2 different villages, and this is actually the second one where we met sort of in a grassy town square, and the people turned out, and the women came, and the women sat here, and then the men sat here. Here is the Serengeti Paralegal Clinic. So when you hear about these paralegal clinics, when we talk about the clinics in the villages, in the regions, this is the regional, right? The regional clinic. This is the big city clinic. This is the big clinic. Just a one-room house, sort of. Was there electricity in there? I don't think. No electricity, no water. Just this one-room house. Inside, lots of literature, some chairs with some tables for people to meet. But there it was, in the center of the town. But they're not big money operations. These are very grassroots, very community based. So that's it. The rest of this is just pictures. These are the men coming out. So the women sat there, the men sat there. This is Helen Kijo Basimba. So she is the executive director and the woman who started this all, Mama Helen. This is her addressing the villagers at the one center. This is my former student, George. He was also there training teaching the villagers. So again, so heartening to see your students go out. All the professors in the room can relate to this, to see your students go out and become great teachers on their own. So that's George, who is Maasai, by the way. And as we drove through the Serengeti and passed through the Maasai villages, he was able to give us a lot of the background information about the Maasai, which was really fascinating. This is Naemy. You recognize her in action, also speaking to the villagers. And that's Raymond, another one of my students. So it was my 3 students. And then this is just after the education, the villagers came up and were talking. They were so eager to learn more about it. They were so interested. And that's just a really, really cool looking guy. That was just, I mean, style is universal, is it not? That guy could be on the cover of GQ. Look at him. So that's it. And then that's my daughter. She came with me, surrounded by children. So that's it. And I just thank you for your attention.
So we have a few minutes left for conversation, questions. Yes, Mika.
The first question is to Professor Marsh. As I understand that you can develop this paralegal program, which will probably raise, they will be aware of the legal rights. But what happens after that? Because who delivers the justice? And because I know, as she was telling, I come from India, and the judicial program, the process can be so long, and it takes years and months to come to conclusion. What happens after that?
You mean after the paralegals are educated, after they become paralegals? They go out to their villages, and a big part of our curriculum, what was so great was that we designed this curriculum by Tanzanian paralegals. And so they know the realities of life in a Tanzanian village. And so part of what we talked about in designing our curriculum was how to identify the influential people in the village, how to get things done in your village, who to talk to. We knew that now in the US you wouldn't necessarily have to teach that, but in Tanzania you do. You have to teach how to make connections and how to get things done, and that is actually part of the curriculum. Yeah.
I noticed in the pictures that Professor Marsh showed that it looked like a lot of the students were men.
Yeah.
Could you talk a little bit about what your experience was? Were there fewer women than men, and was there a sense that women's issues were important among that group of students that you were in?
Well, I don't know the criteria they used when they selected us to participate on the TOT program, but as you're saying, it's true that women were very few in the class. Yeah.
And did people talk about women and justice when you were designing the curriculum, or were people concerned about women in the law and how gender was implicated in justice in Tanzania?
Yes, but not a lot, because we were just trying to design the module for the whole paralegal program. So it was not much more of, gender issues when we were doing the TOT program. Because most of us, the participants there, we were not paralegals, we were just trainers. Yeah.
Yes.
I just wanted to say, and I have many questions. I'm from Kenya. I think I'll limit it to 2. My first, I was thinking about the prevention of injustice, and I was wondering if you knew about how we can bring about the energy of the Ugandan women's movement and other women's movement in the areas into the rural areas, which are predominant in East Africa. And then secondly, because youth is such a large population in the region, how can we talk to youth to transform their ideas, their socialized attitudes about it?
Who wants to go first there? I would leave that to Stella or Naemy. Why don't you start, Stella?
Okay, thank you. Speaking to the issue of the energy of the women's movement, increasingly the developments that I'm noticing or emerging in the region and on the continent is that within various countries, the women's movement is actually coalescing more and more in terms of recognizing that there's a need to bridge that sense of a gap between the community-based organizing and the national level organizing. So you find that they've created forums where they sit and strategize together, but also in terms of the work that national organizations are doing within the communities, instead of going there and working and getting out there, investing in strengthening the capacity of community-based organizations. And like I said earlier, that's the kind of work also that ICRW is involved in, strengthening programming capacities of organizations that are working within communities. The question of the youth, some of my colleagues in the audience from ICRW can also add to this, but we have programs that are targeting young people and adolescents in terms of making sure that their socialization is addressed early on. We have what we call gender equality mainstreaming in schools, the GEMS program, which is mainly implemented through our Asia Regional Office, which involves targeting young boys and girls within the school setting and addressing them in terms of how their relationships evolve and raising their consciousness around issues of violence. And it's an investment. It's an experiment. It seems to be working, and will soon be replicated in other areas. That's it.
Naemy, do you want to add anything?
Yes.
Two questions. First, for Professor Marsh and Ms. Sillayo, if you could talk a little bit about the relationship between paralegals and lawyers, because I'm a law student here, so that's always concerned me a little bit, because there should be a lot more integration in the legal field more generally. And secondly, specifically on the issue of, does ICRW ever look at implementing legal aid laws generally, and what role does that play in pushing better legal aid services throughout the region?
Well, as far as the relationship between lawyers and paralegals that I observed, first of all, it's really tipped on its head, which you might imagine. In the U.S., you'll have these groups of lawyers. You'll have 10 or 12 or 50 lawyers in a firm and 1 or 2 paralegals. It's the opposite. So you'll have 1 or 2 lawyers in a legal clinic. You might have a lawyer in a legal clinic. In one like the Serengeti region one there probably weren't any lawyers. Or was there a lawyer there? No, there were no lawyers. But like in the bigger clinics in Dar es Salaam or Arusha or Morogoro, I think they have 1 or 2 lawyers and then many, many, many paralegals. And as far as I know, and you can add to this, they work pretty closely together.
Because most of these paralegals are working under non-government organizations. And these organizations, most of them are owned by lawyers. So that's the connection. Like you have a big organization in a city where it works with paralegals in the villages. So these paralegals will be trained by these lawyers, and then they'll go back to their communities. And there are times that these lawyers will go to those villages to solve issues which paralegals were not able to solve them. Yeah.
I needed to answer the first.
Oh, there was one more question.
Yeah. She had a question on implementing legal aid legislation. This legal aid legislation is a really new development in the region. All the governments are actually just picking up on the idea of instituting a government legal aid policy that will then inform the provision of legal aid services. So all this has been going on without the regulatory framework of government. But, Tanzania has issued regulations on or is in the process of doing that. Uganda has issued regulations on who should be a paralegal, what should they do within a broader framework of a legal aid policy. So it's a little bit premature, but I would say that in terms of supporting implementation of legislation, what ICRW has done is to work with partners to monitor some of the protective legislation that has been enacted. For example, the domestic violence legislation in India, the Asia ICRW office in the Asia regional office in India has worked with a women lawyers association to monitor implementation of that act, and they've done the same with a similar group in Bangladesh. And we have plans to replicate this model in other countries, starting with Uganda, which has recently passed the Domestic Violence Act. So it's really implementation of protective legislation.
I think we have time for about 2 questions. Christine and then Bonnie.
Yes, I'm wondering if the paralegals also see their role as addressing the customary law and religious law and working with influential figures in the community to bring about adaptations in those spheres of justice, or whether they see their role as exclusively focused on enabling people to access the formal legal system. Are paralegals also looking at customary law and religious law and working with people in the communities to try to change those practices, or not?
Well, they do, but they don't have much influence in changing the laws, yeah.
But they definitely navigate. They navigate those laws. I mean, they're not just purely working in the formal legal system. They know that system more than the villagers would, but they definitely work within. And in fact, again, that was another part of our curriculum, was understanding what was at play and sensitively working through. You don't just go crashing through and say to an Islamic family, you know, you got to do it this way. You just don't do that. And so that was part of what we included in our curriculum, was understanding what law you could enforce and how to work with them. Yes.
Now, last question, Bonnie.
I just wanted to say, I thought one of the most useful aspects that you introduced was that these are communities of women under colonial law, tribal law, and Islamic law, and that there's this trinity. Is there one issue that consistently comes up as a point of all three?
Marriage. Oh, I'm sorry. That's a big one.
Yeah, she really hit the nail on the head. It's marriage and divorce.
Yeah.
Many times, you know, is a challenge, because you will find that whereas you will have been, for example, wedded under, you know, Islamic law or traditional laws, if you register your marriage, you can seek divorce through the formal system, the common law system. And that's where the clash and the tensions begin to emerge, because, you know, in this setting they're saying we cannot separate you, we cannot undo this marriage, or your family has to bring back the customary gifts or bride price that was paid before we can release you. And yet the formal system is saying, you know, irretrievable breakdown. So the tension, you know, arises there, and, you know, eventually, obviously, if you go through the formal system, you will get a divorce secured, but working through the implications of that in the community where this person, you know, has to go back and settle or live remains a challenge that we need to work through.
Sorry, I think we're at the end of our time here, but thanks to all three speakers. From the law school and also the School of Professional Studies for co-hosting this with us. Thanks to also particularly to Stella and the colleagues from ICRW, which could you stand up, please? So people can see. Pointing out much of the work that Stella was mentioning, and I will mention that they live right down the street, so hopefully we'll be seeing a lot more of them. And finally, If you like this event, there will be many more, and please support us by attending, to begin with, our launch, which is going to be on November 27th, and we will be giving you more information. So thanks again for coming.